Namaste and very good morning to all the participants, all the invitees. Very good morning to today's guest speaker, Professor Dr. G. Mohan Gopal sir, former director of the National Judicial Academy, Bhopal. A very brief introduction is sir has been former director, is a former director of the National Judicial Academy, Bhopal. Sir has been associated with the judicial and legal education since more than 2 decades, I think 3 decades. Yesterday, we started these sessions. Yesterday, we discussed the concepts of securing justice. How do we understand the Constitution? How do we understand the justice? How do we understand the rule of law? And today, we will be on the topic of securing justice, institutionalizing QRTE means quality, responsiveness, timeliness, and efficiency of courts within the existing constraints and role of presiding officers. I once again welcome you, sir, for this session. I also welcome all the honorable justices who are attending this webinar. Sri Lanka, Nepal, India, and all honorable directors of the judicial academies and all honorable registrar generals, registrars of the honorable high courts, all the principal district judges, family court judges, and all other court judges, public prosecutors, principal magistrates, and members of juvenile justice boards, students, staff members, and all. I invite all, I welcome all of you without spending much time. Now I request this guest speaker to take over the session. So once again, welcome and hand over the session to you, sir.
Thank you very much, and Mr. Yarlagada, and very good morning to all the honorable judges. Yesterday, I was delighted to read after the session over 250 comments and questions which came from the honorable judges. I've sorted them out into 11 areas. And I'm going to deal with them at the end of our session because hopefully some of these would be covered by the time we finish. But I'm happy to say that the largest number of questions and comments were on the conceptual issues of justice. So that means that there was a lot of interest in discussing the thoughts that we shared on how to understand justice and the Constitution. So that was the one big area. And our second, almost equally, slightly smaller, but another big area was how to apply this concept of justice, or how to secure justice in applications. In fact, that is what we will focus on today. And then there were also some conceptual questions on the role of courts, adjudication versus justice. What is exactly the role of courts? Again, from a practical point of view. And the next 2 or 3 issues that on themes were how justice can be reconciled with rule of law, court management issues, how the interface between justice versus law, consistency and subjectivity, reasoning, and the relationship between justice and society and morals. Now the issues are getting smaller. Compassion, there were 4 comments on the issue of compassion, and then there were a couple of other miscellaneous comments. So we can see that the main interest of the group is around understanding, is conceptualizing what is justice. It is probably the most important issue in the judicial and legal system because we haven't examined it in detail, and we have started that process, but we need to be clear about it. The medical science has given doctors a much stronger framework to define what is good health. Just as doctors are concerned with the core question of whether someone is healthy or not, And health is the core issue that the medical system deals with. As we suggested yesterday, the justice system is the core concern of the justice system is right conduct, And I've given you a simple understanding that because of the word use, I'm not giving you my own sort of personal view. I'm giving you a basis for that view. The word use means the value of right conduct, the value of right conduct, and therefore justice refers actually to to right conduct. If you want to define it in two words, it means right conduct. Then the question is, what is the benchmark? And I'm submitting to you that we must find that benchmark in the constitutions of India for Indians and for other countries, and in the constitutional history of other countries, because the constitution is actually the foundation of the creation of a nation state. For state officials and all those who work with the state, the constitution becomes the main document. Now, the constitution we mentioned yesterday has two sides to it. One side is its governance side. It creates power, it vests power, it allocates power, it limits power, and that's an important function of the constitution everywhere. But we also know that jurists have always referred to the constitution as setting out the Grundnorm. And so for the justice system, not for the legal system as a whole, but the justice system, because justice is concerned with use, J-U-S, that's why it's called the justice system. And J-U-S simply means the right value. And therefore the justice system is concerned with the norm, the standard of right conduct, because the purpose of the justice system as a subset of the entire legal system is to uphold right conduct. Now that right conduct may mean, and I've based on several years of working with thousands of Indian judges, my hypothesis is that most Indian judges understand right conduct as in around two themes. One is they believe that right conduct is that everyone must get what is due to them. And so when they decide, that's a very overarching consideration in their mind, that they must get what is due to them. That is right conduct, making sure that everyone has what is due to them. It's a distributional idea of justice, which is also there in jurisprudence. The second big idea of justice, which I find applied in the application of and the actual decisions of Indian courts, is the idea of order. That order must be maintained. That there should not be disorder, whether inside the family or in the state as a whole. Order should be maintained. Now, so conduct that maintains order is seen as right conduct. Conduct that disrupts order is seen as wrong conduct. And that is why many judges, in fact, until 1964, every single Chief Justice of India had been appointed as a judge by the British in the colonial period. It was in 64 that for the first time a Chief Justice of India was appointed who had not been a High Court judge under the British. So for a long time, the same attitude prevailed in the Raja era and the Raj era, that there should be no disturbance, order must be maintained. But you'll find that the most orderly place in any town you go into, the most orderly place is the graveyard. Not a single body moves. Nobody questions. Why am I in this grave? Why not in the other grave? How come the other grave is getting shade? I am not getting shade. Nobody moves, nobody questions. So society that does not question is a dead society. And when you question, the given order is disturbed. You find that there is disorder in nature. It's a natural state is constant change. The nature is constantly dynamic. The existing order is constantly challenged and constantly reshaped. This is natural. Stopping that process by insisting that the given order must be maintained is giving a death sentence to society. And so the only option for us is to make sure that that the questioning and the disorder and the reordering, I will not say disorder, questioning and reordering. There is no disorder in nature, but there is reordering. That process must not be violent. It must be peaceful. It must be non-violent. So we celebrate the fact that India, one of the only countries in the world, questioned the order of colonial rule and wanted to reorder India, as we said yesterday, constitute India into a republic, make India something it was not, a democratic republic, socialist, secular, democratic republic. By non-violent resistance against the given order, not by violent resistance. So we are committed to a dynamic society where the given order is constantly, like in nature, constantly challenged in a dynamic way, and that given order gives way to a new order and a better order, but in a non-violent way, in a passive way. So we celebrate the questioning of the old order and the reordering of society in a non-violent way, which is what gave us a new and independent republic. And therefore, these two ideas of right conduct, namely that a distributional idea of justice, and justice, right conduct as conduct that does not question, does not create any disorder, or and suppresses questioning to such questioning as will not question the current order, even for a good purpose or a bad purpose. This idea of justice is coming in the way of the constitutional idea of justice. The constitutional idea of justice is very different. It says, we want a society where right conduct means a conduct that supports and respects freedom and liberty of everyone to question the existing order or support the existing order, but to the liberty to do that. Right to equality, right to dignity, right to fraternity. So we have a country which has been opened up by the Constitution to encourage and allow people to question the new order, because we want to create a new order where there is no poverty and no suffering and no inequality. And everyone has liberty, equality, and freedom. This is our aspiration. So the Constitution has created a framework for questioning the existing order, because the existing order benefits a small number of people. According to a very recent survey by Pew Research, a very respected data institution in the United States, 97% of the population of India live on less than 25,000 rupees a month for a family of 4. And that is, by global terms, low income or poor, 97%. Now, do we want to maintain an order in which only 3% are not low income or poor? The answer is no, we don't want to. But the Constitution gives us a framework for reordering ourselves into a better order where there will be well-being and welfare for everyone. And that is, so the Constitution has a dynamic process of change. The Supreme Court of India in 1980, S.P. Gupta versus Union of India, called the Constitution of India a charter for social revolution, a charter for social revolution. Right? But the tradition in the judiciary is to see justice as giving people what is due to them without any disorder or without questioning the order, which means giving what is due to them under the current order. And this view of justice of the Constitution, which speaks in its preamble of liberty, equality, dignity, fraternity, is colliding with the inherited traditional ideas of justice of the judicial system. And what we are trying to do, I am trying to do, I'm an individual, I'm not speaking for anyone, is to try to align the concepts of justice which are applied in courts on a day-to-day basis with the constitutional idea of justice, and say that for us, justice means freedom, equality, dignity, fraternity. And unless these four values are upheld and promoted, to take the words of Article 39A, the operation of the legal system shall promote justice, then we will not achieve the constitutional aim of reordering our society, constituting India into a republic in which there is welfare and well-being for all the people of India, not just a 3% of the population. So this is the tension here, and so when I challenge the idea of justice and say it is not just about everyone getting their due share under the existing order. Yes, everyone must get their due share, but we need a due share based on the principles of equality, liberty, fraternity, and dignity, not on the current order. And yes, this change must, which the Supreme Court described as social revolution, must happen in a non-violent and peaceful manner through constitutional means and not through extra-constitutional, violent or extra-legal means. We are desperate. I am desperately struggling to make this happen so that we will not descend into violence. We are on the verge of violence. We should not forget that Baghdad is only as far away from New Delhi as Trivandrum is. That Kabul is only as far away from Delhi as Nagpur is. And so the region is on fire. Societies are descending into chaos and violence from which they cannot be retrieved. And when that kind of internal conflict takes place, outsiders come in and take over the place. That's what has happened in our history always. So we have to do whatever we can to establish, as Justice Rabindra Bhatt says, fraternity in our country. His judgment really gives primary importance to fraternity. Because when you have fraternity, that becomes a foundation of unity in the country and stability in the country. Genuine fraternity. So that's why I said that we want fraternity, and we realize that for fraternity, we need mutual respect based on equality. We need dignity. We need liberty. That is the kind of fraternity we need, not fraternity amongst unequals in a hierarchical society. We want fraternity amongst free equals based on their dignity and based on their self-respect. That is the formula of the Constitution. Therefore, unless every decision in every case asks the question, simple question, which is what Mr. Vishal Gogone asked in the case that we will look at first. How are we treating each other? How are we treating each other? And are we treating each other, respecting each other's, on the basis of fraternity, friendship, mutual support, caring for each other? And compassion is a part of fraternity. It's not separate from fraternity. It is the basis of fraternity. So are we looking at each other based on the principle of fraternity, on the basis of equality and mutual respect, on the basis of liberty, and on the basis of democracy? And if we are not doing that, then the judge, as the auditor, the guardian, the protector of constitutional right conduct, must come in and correct that. And that's what Mr. Vishal Gogone did. It's one example. There are many such examples. I'm very fortunate that since I've worked with very large number of judges, they sometimes share with me the fantastic judgments that they write. And whatever I'm telling you now is really based on what I've learned from them. So what I propose to do today is we will first look at the judgment of Mr. Vishal Gogone granting bail in Delhi, very recent judgment, a few days ago. And we will try to understand whether his approach to justice is consistent with this approach that I've just described. Is he asking the question, how are we treating each other? And then is he finding the law Justice Krishnaiyer once said that as far as a court is concerned, the challenge of justice is finding the law to uphold the values, not to be an arbitrary ruler imposing his personal sense of right or wrong, because that, we will come to that again, is fundamentally opposed to the idea of a democracy. It's a very dangerous idea. We did not throw the British out to have 20,000 judges ruling us. And so we don't want anyone ruling us. We want the laws that we create as a people, including all the judges, all of us as a people. We create the laws through a democratic legislative process, and those laws must be interpreted in a manner that advances the purpose of those laws, which is to establish a society based on fraternity. Given all the differences, all the conflicts we have, religious, caste, regional, resource-oriented, environmental conflicts, all kinds of conflicts, if we don't give primary importance to establishing fraternity and solidarity based on equality and liberty, then we will go the way of Iraq and Afghanistan before we realize it. And so it's a very serious battle that we are fighting, and the courts can and have, as we have seen in this case, ensured that mistreatment under constitutional standards, not under personal standards, mistreatment under constitutional standards and legal standards is corrected by a court. So with your permission, sir, will you display it or will I display it, sir? Shall I display it?
Yes, sir. Please display, sir.
Yes. With your permission, yes. This is an order. It's not really a judgment. It's a bail order, but it's a very, it's a very important bail order. Now, sir, can I request you, because you have read it and you have a lot, can I request you to give some comments, sir, on this judgment from your point of view in the absence of any other discussion? And I would be happy if there are any comments that are shared by any of. Yes, sir.
Thank you, sir.
For ability to talk. Yes, sir.
Thank you for giving me this opportunity. But I look it from more than one angle, sir. Some orders, even bail order or even a judgment will be like this. We will discuss what this side has argued, that side has argued, and we will quote some citations, etc. And we will proceed to pass with an observation. The following order will meet both the ends of justice. This will be one method without discussing what we understood from those arguments and from those authorities. And in another situation, this is one example of that another situation where the judge expressed his understanding of the values, the concepts, etc. And then he proceeded to pass this order, reasoning. So that difference I have distinguished it, sir.
Yes, sir. Anyone else has any comments, or do we have anyone else who is able to comment?
Sorry, it's not there in the.
Okay, in the program, in the platform, we are not able to do it.
Yes,
okay, sir.
Yes.
Fine, sir. We will work with this. Now.
So 13 onwards, sir.
Yes, sir. Yes, sir. But yes, sir. In 11, see the facts of the case. I assume that everyone has read it. It's a serious case. The allegations emanate from the FIR. Complainant alleged that his daughter, who had been married to accused Tinku, was subjected to repeated demands for a motorcycle. So dowry. His younger brother, namely Sunil, his elder brother, namely Deepu, that is, and Suman, it is elder sister-in-law Suman, who is the present application, and father-in-law Dilip Chowdhury. They were all making demands on her. She could not provide the girl's family could not, the wife's the complainant could not, the father could not provide the motorcycle. for want of resources, which led to the accused persons repeatedly beating up his daughter. She was not provided proper food and forced to consume non-vegetarian food. It was further alleged that she was kept hungry for 4 to 5 days. These are the realities in our country. Should we not challenge such a social order? Should we not reorder it so that, I'm the father of 2 daughters. I have no sons. I'm a son myself, but I have no sons. I can imagine the pain of this father to see the daughter in this condition. The specific allegation against the present applicant is Suman Kumari was that she had intended to get her sister married to Tinku, so forcibly made the deceased consume a medicine to cause abortion of a 3-month-old fetus. It was alleged. These are not established facts. The deceased was found hanging, that's a fact, with a ceiling fan using a gamcha, a cloth, and so discovered by her husband on 1/12/2020. So this is very recent. It's December 1 last year, in the middle of COVID. The learned counsel for the accused. So what the accusations are very serious, no doubt, and heartrending. So our counsel for the accused made the usual arguments, which we need not get into, and then we come to para 11. While agreeing that the child of the applicant or accused is quite young in age, the learned APP. So if I should say, APP submitted that he had not been separated from his mother and was in a safe environment in a company. The court has considered the charge sheet and the submissions made by the respective counsel. Now we come, para 13. Apparently, the allegations relate to demand and harassment with a view to obtaining dowry and beatings inflicted in this context. They also relate to forcible administration of a pill to cause abortion of the fetus of the deceased. The pleas raised by the learned counsel for the accused with respect to the merits of a charge under section 304B would be considered by the court at the stage of framing of the charge. Whether for purpose of framing charge the allegations constitute harassment for dowry soon before her death is a question or stage yet to be reached at the trial. Specific allegations have been forwarded in the charge sheet. The gravity of the same cannot be discounted and thus operate as a dissuading consideration in the matter of bail being granted to the present applicant or accused. Now we know that this application, as all of you know, but for just for the so that we are all on the same page, this decision or the application for bail is being made under section 439 of the Criminal Procedure Code, which says a high court or a court of session may direct that any person accused of an offence and in custody be released on bail. Right, and then there is if there's previous conviction under 437(3), not relevant here, which it considers necessary for the purposes mentioned. That's not so. Any person accused of an offence and in custody be released on, may direct that any person accused on offence and in custody be released on bail, that any condition imposed by a magistrate when releasing any person on bail may be set aside or modified. So very broad power given to the sessions judge and the High Court, which simply says any person accused of an offence and in custody be released on bail. So if we read this only as a legal provision, then we say, to what end, for what purpose should this power be used? Every power is given for a purpose, and that is central to the idea of rule of law. Limited power, the power is only for a purpose. In a feudal society with a Maharaja, you have power given for any purpose that the individual, power is given to the individual. Here the power is given to an official, not to the individual. The judge is a function, not a person. It's a function and not a person. And so if you look at section 19 of the IPC, section 19 section 19 of the IPC which defines judge. Now, first, court of justice. Words court of justice denote a judge who is empowered by law to act judicially when such judge or body is acting judicially. So we know that this court has to act judicially. Judicially comes from the word jus, J-U-S. That is the root of the word judicially. So ultimately, to act judicially means to uphold the right value, the right use. And then the word judge is defined in section 19, and in the illustrations in section 19, it says a magistrate exercising jurisdiction in respect of a charge on which he has power only to commit for trial to another court is not a judge, is not a judge. So please understand that a judge is not a human being. When a magistrate sits in the court and commits somebody to another court for trial, he is not a judge according to the law. He's acting in an administrative capacity or some other capacity, but the law says he's not a judge. Therefore, we must understand that the law, the concept of this is the rule of law. That if we believe that a judge is a judge when he's brushing his teeth, he's sleeping, he's getting up in the morning, he's having a shower, when he's talking to his, his staff, he's a judge. But actually, we are like a professor is a professor only when he is in class teaching. We think a professor is a professor when he sleeps, gets up in the morning, brushes his teeth, talks to his staff. That's just a colloquial usage. But a professor is a professor only when he's teaching in a class that is authorized and expressing a view that he's supposed to independently express, like a judge, for the purpose of advancing education. So therefore, when we come to section 439, although, and I'm responding to many of the questions that were asked, that's why I'm going into in some detail. When we're looking at section 439, it seems to be written in extremely broad terms, like Article 142, complete justice. By the way, the word complete justice is only for the Supreme Court. Section 151 of the Civil Procedure Code simply says for the ends of justice. So I don't know why we are now suddenly talking of everybody doing complete justice. The law has not given that mandate to anyone except to the Supreme Court. But even that is given not to the judges who happen to be sitting on that chair, but it is given to the function of a judge. And it is therefore to be, we have to ask the question, how do you interpret such a power? And my submission is, you have to read every such provision in conjunction, must be read with Article 39A of the Constitution. And what does Article 39A of the Constitution says? I can tell you by heart. It says the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity. We read it as a legal aid clause, but legal aid is only an instrument to achieve the real substance of that clause of the Constitution, which basically says that the operation of the legal system shall always promote justice. So therefore, in deciding whether to give bail under 439, the judge, not the individual, the judge, the function of the judge is to ask what is the purpose of this function for which this power has been given, and that is to promote justice. So let us deal with that question of what is discretion. Discretion, that is to be is a function of the judge, where when, as in 439, when there is no clarity about what is the basis on which bail should be given, that function requires us to separate the grounds of that decision which are authorized by law from those that are not authorized by law and are purely subjective. Because you have had a sense of, a number of questions say that, look, we know what is going on. When the judge has knowledge which is not on the record, The individual may have knowledge which is not on the record, but please remember the judge never has knowledge which is not on the record, because the judge is a function. So therefore, the challenge of discretion is to separate what is subjective, what is personal, what is not on the record, and look at the Constitution, look at analogous provisions of the law, and derive from there through the doctrines of interpretation, authorized doctrines of interpretation, the principles and grounds that can be relied upon to exercise this function to advance justice, because that is the role. And justice, as I said, there are two broad views. One is the view that justice means, actually the original traditional idea of justice in the Raja era was Dushta Danda, Sajana Puja, Kosha Vriddhi, Rajya Raksha. Dushta Danda, Sajana Puja, Kosha Vriddhi, Rajya Raksha. So yes, you give bail subject to these four concerns. Dushta Danda, so there is a Dushta has to be given Danda. We assume we through judicial instinct, the judges know who's really guilty and who's not, and that's why they say, I have personal knowledge. That's not consistent with rule of law. The rule of law, there is no individual judge, there is only a function, which is why 19 says, the illustration in 19, section 19, it says that a magistrate who's only committing for trial is not a judge, because that's not a function that is judicial in nature. You're just transmitting. It's like you're just transmitting the case from one court to another court. There is no application. There is no responsibility to uphold use, which is the root of both judicial and judge, which is the function of the judge. And therefore, we have to understand this is where the application of the idea of justice is very important, and where this judgment immediately asks that question. Does not say, look, I have unlimited discretion. So discretion is actually not meant to give you personal power. On the other hand, discretion is meant to ensure that you do not exercise personal power, that you separate the grounds that you will take outside the statute, which are legal, from those which are not legal. Okay, so now let's see how this judge, Mr. Vishal Gogane, approaches it. He says, he first starts off with a very high level statement. What is a court? So he just doesn't look at 439. He says, okay, I'm in a court. What is a court? And we've said a court we've defined court as an activity where a judge is acting judicially. And for that, you require all the parties and a procedure to be followed. So he says, a court of law is a forum where the right to liberty has to often yield to the rule of law. And persons accused of the commission of offences may find their applications for grant of bail decline for various reasons. So he's looking at the function, that there is a right to liberty and the rule of law. Denial of bail to such persons, especially women, does, however, often operate as a de facto detention of their infant, toddler, or wards. Being neither the subject of trial nor required to be in detention for any reason, such children still languish in jail for terms coterminous with the period of detention of their mother. So he says, look, I have to protect the right of liberty. And yet, when the law authorizes detention, liberty has to be deprived in the interest of the liberty of others. But he says there is one factor which we are not taking note of, he says, not in so many words. He says, especially women, when we put them in jail, we are also putting their children in jail. And there is no legal basis for that. So now he looks at the law. India is a signatory to the United Nations. Look at the level in which he's identifying what is justice. What he's doing is he's understanding the Constitution and understanding justice in this bail order, If you tell me you have no time to do this, if Mr. Vishal Gogone has time to do it, then I think we all have time to do it. He's a very busy judge. I've had the privilege of interacting with him when he was at the Judicial Academy. And frankly, time comes because very often things take a lot of time because of lack of knowledge. If there is knowledge and competence, things can move very quickly. So the lack of time is not always, but very often overcome by ensuring that we are intellectually well prepared. So Mr. Gogone is intellectually highly prepared. He reads a lot, he thinks a lot. There's a deep reflection on what courts do and what justice is, as Mr. Yaralagada does. I'm sure he disposes of matters like Mr. Gogone very quickly. Now he says, so he immediately is already within his knowledge. No, no one has to tell him that India is a signatory to the United Nations Convention on the Rights of the Child. And so he's now entering into the core question of justice, which is how is the state treating this child? Is the state treating this child in a fraternal manner or in an inimical manner? So he says the convention mandates that detention of children should be only a matter of last resort and for the shortest period of time. And even if it is required, it says that children should be separated from adults. The primary consideration of the best interests of the child in all actions concerning children taken by courts of law, enunciated in Article 3 of the Convention, finds recognition in the Juvenile Justice Act of 2015, which actually in the year 2000, the original version, arose from the United Nations Conventions on the Right of the Child. Through Section 3, which requires that all decisions regarding the child shall be based on the primary consideration that they are in the best interest of the child and to help the child to develop full potential. Section 3 also advocates, so look at how he is not acting arbitrarily. He's saying there is a law that to implement the constitutional vision of liberty and fraternity. There is a law that provides a standard of conduct, a standard based on which we should treat a child. Section 3 also advocates institutionalization of the child as a step of last resort. The same provision mandates that a child in the juvenile justice system should be restored to the same socio-economic status and cultural status that he was in before coming under the purview of this act. The child of the applicant is 21 months old. He has not yet seen 2 years in this world. Not being a child in conflict with law or a child in need of care and protection within the meaning of the JJ Act, not within my personal view, but within the meaning of the JJ Act, it may be a view too myopic and pedantic to take that the child is not in the juvenile justice system and therefore the law does not apply to the child. So he understands that the principle, this is like I said yesterday, if I tell someone do not use the word tu, but that person uses an equivalent in another language, it would be too myopic and pedantic to say that you should understand my purpose. My purpose is we must treat people with respect and dignity. I was not focusing only on tu. So we must understand the higher purpose for which law is made. A very experienced judge once told me, he said, Professor, every law is made by the legislature to advance a good purpose. That purpose is not written in the legislation. It is often not even written in the preamble or the objects clause. But the challenge of the judge is to identify that good purpose and ensure that and to safeguard it and take it forward. That's what Mr. Gogone is doing here. He's saying that the purpose of the Juvenile Justice Act is to establish a certain principle of conduct, a value of conduct on how we treat children. And so it would be too myopic and pedantic to say that you first have to be a child in conflict with the law or child in need of care and protection of the law to be treated properly as all children should be. So the court would pose to itself whether for reason alone of not conforming to the above description as CCL or CNCP, the child can be denied the protection of the principles governing the child rights regime. The answer is an unequivocal negation of such a proposition. Being only the son of an accused, and yet suffering de facto detention, the child must not suffer rigorous, any more stringent than a child who would qualify as a CCL or CNCP. Yet the child filed himself incarcerated for the alleged actions of his mother. It bears empathetic, but emphatic mention that the continued detention of a child of a tender age, even if in the custody of the mother, would have a foreseeable adverse influence on his socialization, sensory enrichment, and overall physical and mental development. This is the heart. This is not Mr. Gogone speaking. This is the Constitution speaking. This is the Constitution speaking. This is where fraternity is based on compassion. This is an illustration of compassion, where he's drawing compassion from the Juvenile Justice Act. And he says, look, when you say the best interest of a child of 21 months of age, we have to be conscious about how that human being, that little bud, is flowering in a jail. The options for preschool and other educational enhancement would necessarily be restricted inside the central jail. Since the trial has not even commenced and is likely to take a length of time to complete, the son of the accused, barely two years in age, it could be the title of a good movie, The Son of the Accused, barely 2 years in age, cannot be condemned to spending, because there are so many of them in this very tragic condition of being punished for no fault of their own, cannot be condemned to spending his early childhood in jail. Such a fate would be a violation of his right to healthy development as an individual. All of these are constitutional values. Of his liberty, which includes his Article 21 right to life and liberty, personal development, thus in recognition of the rights of the child, and observing that a system which is predicated on the presumption of innocence and of the accused should not subject the child of such an accused to detention without cause. The court finds it fit that the applicant is granted liberty to face trial as a free person. Bail to the applicant is in fact a release of a little child to freedom. Now, this is an example of the application of everything we discussed yesterday, where we are saying, look, what a court does is to protect the values that should inform how we treat each other as human beings. Take all the institutions, organizations, laws, and all that aside. Ultimately, we are human beings treating each other. The rule of law says you are not an individual treating someone else. On behalf of the people, you are a function. And that function must treat each other in the manner prescribed by the Constitution and prescribed by the law, according to the principles that are in those documents, instruments. And that is what this judge is doing. There is nothing arbitrary, nothing personal, strongly reasoned, based on law, advancing the constitutional values, and seeing justice as a protection, as a standard of human conduct, according to the Constitution, seeing justice as right conduct, and saying that the conduct towards the child is not right, and therefore justice means upholding the right conduct. So let me stop here on this discussion and see if you had anything to say. So my emphasis here is not on the final decision. My emphasis is on the reasoning, how he understands the four, actually five is the fifth plus one, the four forces that uphold the judicial system, the physics of justice, the four forces that uphold the judicial system, namely the Constitution and its values. The Constitution's Grundnorm, not just the administrative governance part of the Constitution, but the Grundnorm of the Constitution. Then the idea of justice, not just as Dushta Dand, Sajana Puja, Kosha Vriddhi, Rajya Raksha, but as upholding justice as freedom, justice as liberty, justice as equality, justice as dignity, and the rule of law, that there shall be no arbitrary, personal, subjective decision making. A judge is not sitting there like some Maharaja to dispense justice as he sees right, but justice as a function carried out to advance the constitutional vision of justice in accordance with law. And reasoning. How he has taken the facts, as I said to you yesterday, and we'll go into it in more detail, reasoning, and we'll find the definition of reasoning a little later in the Evidence Act. In the Evidence Act. It is about how facts are connected to each other. So Mr. Gogone takes various facts. This woman is accused of a serious crime. This woman is in jail. This child is in jail. This child is 21 months old. The atmosphere in the jail, the rights of the child, the principles that should govern how a child should be treated internationally and in international law as well as in national law. And he connects all this together. And when he connects all together, a result necessarily follows. Necessarily follows. And when these four forces of the judicial system that uphold the judicial system come together, the decision becomes very strong. Now, these forces are not obvious to you. Like every morning, a pilot is not given a report on how much gravity there is. Today, gravity is more, gravity is less. Gravity is always there. Gravity is uncompromising. The pilot can have whatever discretion he wants, but if he violates gravity, he will crash. There's no compromise on that. You cannot violate gravity. You cannot violate drag. You cannot violate the air and the movements of the air. You cannot violate the physics of lift, that if you burn so much fuel and push so much air, you will get thrust. These laws cannot be violated, but they're not told to him every day. But when he's sitting in that pilot seat, these are the four laws that are governing the pilot. Similarly, Mr. Gogone is sitting in his chair, and the unseen, invisible, non-negotiable forces that have put him in that chair and will protect him in that chair, our constitution, the idea of justice, the rule of law, and his reasoning. And if he fails in reasoning, he will crash. If he violates the rule of law, he will crash. If he does not understand justice properly, he will crash. And if he does not understand the constitution properly, he will crash. But if he takes the effort to understand all this through reading and learning, then the jury function of simply deciding whether this woman gets bail or not, is punished or not, is easy for anyone to do. In the most educated countries in the world or least educated countries in the world, ordinary people with no expertise are making these decisions as jurors. But understanding these four forces and ensuring that those four forces are respected and not violated, that is a very technical, very involves and requires a lot of learning and a lot of knowledge. And our judges, especially the younger judges, are easily going just to the jury function. And I'm always saying, actually, in many of our courts, we have the jury system, except we have a one-person jury who is simply jumping to the jury function. And these other four forces are getting neglected, which is really what holds the judicial system afloat. And in this judgment of Mr. Vishal Gogone, you see how these four forces are operating to produce his judgment. And that's why I thought I will share this with you. This is a very recent judgment, 31st of March. Let me stop here, sir, and see if you have any comments or any comments have come through.
Sir, you have covered those queries. Just now I was about to say how again completed.
Yes, sir.
Yes.
Yes, sir. Okay. I wish we had a process of physical interaction. I mean,
sir, I even got a message from the participant that I think the esteemed speaker has substantially answered my query.
Okay, sir.
So that's what they are getting the answers also through this section. Please continue.
Sir, should we take a break now, sir, or take a break at a little bit later? Because now I would like to discuss the George Floyd instructions to jury.
I would
But,
suggest we continue and later on take a break, sir.
yes, sir. We can take a break like yesterday around 11:30, 11:45.
Yes, yes, sir.
Yes, yes. Okay, sir. Okay, so I'll just not jump into the other thing. I'll just give everyone a minute or two to think, because I'm sure many people don't agree with me, and which is good because I'm the one who's preaching that there should be disagreement, there should be questioning. Every given order, if our country is to have a good future, we must always question the existing order and want to create a better order. Our mantra should not be maintain order. Our mantra should be build a better order, no matter how good the order is. No matter how good the order is, build a better order. Let's have something even better than what we have. That's what we owe our children and our grandchildren. And you're all very young to talk, too young to talk of grandchildren, but that's what we owe the future. So we see Mr. Gogone not seeing Section 439 as a blanket personal discretion to grant bail or not grant bail, which is how you can read 439. But you see him understanding his role, his function, and these four forces, and applying these four forces, and then it reaches a result. Frankly, whether he gives bail or not gives bail is a juror's decision. I am not interested in that. I am interested in the reasoning, the process by which he has reached that function. Yes, sir. Yes, sir.
Sir, as you said, sir, that there should be some disagreement with your view. Again, it is there, so I may be allowed to put it.
Yes, please, sir. Please, sir.
Sir, while I appreciate the learned judge's sensitivity and compassion towards the child of the accused.
This you're reading a comment, sir. You're reading a comment.
Yes, sir. Yes, sir. Yes, sir. While I appreciate the learned judge's sensitivity and compassion towards the child of the accused.
Yes.
What about the examination of the question of bail vis-a-vis the nature and gravity of the crime, its impact on the society, etc.? He adds, sir, not a single parameter was laid down by the Honorable Apex Court in the case of Prahlad Singh Bhati case or P. Chidambaram's case for grant or refusal of bail has been discussed or examined in the order. Has this order done justice to the victim and the society?
Sir, again, thank you very much to the Honorable Judge for raising this question. And it shows, I think, again, it goes back to the point of if I could have the pleasure of discussing with him, the first question I would have asked him is, what legal principle or constitutional principle is he basing his argument on? Where is the constitutional principle that a person who is entitled to, as Mr. Gogone says, is entitled to the presumption of innocence? This person is an under trial accused, not convicted. But the questioner is assuming already that releasing a person who is accused by the police, sir, see, my father was a police officer, Indian Police Service, so I mean no disrespect to the police. He was an army officer, later became a police service, so I don't disrespect to the police. But he was one who all his life fought against corruption in the police, sir, and suffered for it. He became a very senior officer, but he suffered for it. There is massive corruption in the police. We know that. Why are we taking at face value, sir, what a system which we know is very, very corrupt is putting before us and assuming that a person is guilty? I'm not saying the person is innocent, but that will emerge from a process. Now, if you read the structure of the Indian Penal Code and the Criminal Procedure Code and the Constitution together, the reason why 439 is so sweeping is you will find that in the Criminal Procedure Code, there is a provision on arrest, which limits the power to arrest. There is a provision on bail, which gives very broad power to give bail. There is no provision to imprison an under trial person except under Section 4, the parameters laid down for a person who are arrested under non-bailable offences in section 41 of the CRPC, which means that the presumption of the law is that in the normal course, except in exceptional circumstances, a under trial is not put in jail. But the fact today is 70%, 70% of the prisoners in our Indian prisons are under trial prisoners kept there by judges. 70%. But the presumption of the law and the constitution is, there is a provision in the Criminal Procedure Code that once you're convicted, you will sent to jail. You will be convicted, and in the Indian Penal Code, you will be imprisoned, sent to jail. But there is no provision for keeping in jail an under trial prisoner as a process of punishment or in any other capacity. This is, you can arrest on these limited grounds, and then you've got a broad power to give bail. This is why Justice Krishna has said, bail, not jail. Not because he was expressing his philosophy. This is the philosophy of our law. Why? Because the ultimate, as just Mr. Gogone, Judge Gogone has said, he talked about liberty. But he's saying, yes, now where are these other considerations saying that because you are accused by the police of a serious crime, Section 41 says, if the crime is serious, the gravity of the crime is one of the reasons why you may be kept under arrest. But the real purpose you're kept under arrest is because it's a serious crime and you may flee the jurisdiction, and the serious crime may go unpunished because somebody has fled the jurisdiction, or you have tampered with evidence, or interfered with the process of justice. Or you're a threat to others. You've committed a serious crime, and if you're not detained, you may commit further crime. But the point that the honourable comment, the speaker who has given the comment has made, which I would with great respect, want to understand further is, how can we say that because a person is accused of a serious crime, that person must be kept in jail? Sir, people are sent to custody for custodial interrogation. Article 20 has a right against self-incrimination. In fact, the question examined by the Supreme Court has been, can you interrogate while in custody? And the Supreme Court has said, yes, you can interrogate while in custody. But we have gone further from that and said, look, can you be sent into custody for interrogation so that you can be intimidated? You can be put under harsh conditions and then forced to construct a case against yourself. So the police in our country expects every accused to construct the case against the accused. The law gives us the right to silence. Now, the question of the victim has to be separated from the question of the right of a fair trial to accused, which God forbid that no one in this audience will face that situation. But you and I know, sir, including in Bombay, cases where judges have been accused of crimes. Rare cases where a judge has been accused of a serious crime, including under Makoka. And when that happens and the judge languished in jail, when actually he was acquitted, eventually he was acquitted when the trial was carried out, he was acquitted. But he languished in jail, he was dismissed from service. And by the time he was acquitted, his health and his mind had collapsed to such an extent that he died before he could be restored to office. So these are principles that will protect all of us, sir. I don't know whether that judge, when he was a judge, I don't know at all. Maybe he did, maybe he did not. Whether he was conscious of the importance of the right against self-incrimination, the right the presumption of innocence, the right to silence. These are all fundamental principles, sir, of the idea of justice, natural justice. The two principles of natural justice, the audi alterum partem and nemo judex, that you have the right to be heard, and no one can be a judge in his own cause. These are all part of the idea of justice and sub-part of the idea of liberty. These are all very important this is the only reason we have a judge. If you wanted to punish whoever the police finds as an accused and put that person in jail and give solace to the victim, sir, I feel then we don't need a judicial or legal system, sir. We don't need law teachers like myself. We don't need law students. We don't need lawyers. We don't need judges. The police can do all this. Why should we come in the way? We are there only to protect these principles and protect liberty. And as far as the victim is concerned, every help must be given to the victim as in other countries, regardless of whether a person is accused or not, convicted or not. That is the right of the victim and our responsibility to the victim. Financial help, psychological help, physical help, material help, all should be given, because when a person is subjected to a crime, that victim, it is society that fails that victim. And most countries in the world have separated the question of crime and punishment of the accused, a victim of the crime and punishment of the accused, which is the right thing to do, because especially given the deep failures, How many senior judges, sir, I can't count, have said that the criminal justice system in our country has collapsed. And yet we are saying that someone accused by the criminal justice system, not convicted of any crime, should be kept in jail to give solace to a victim. We are saying that, sir. I can understand, layperson saying that. Yes, sir.
Sir, there are such similar expressions. What is the, are we not concerned with the victim also? That is what they have expressed. You have covered,
Yes,
sir. Thank you.
Yes, sir. I've answered that, sir. Sir, let me now then move, for lack of time,
yes,
to
please,
the next. The next part is, before I get into George Floyd, I want to connect these two, sir, by answering a number of questions that were asked yesterday on reasoning, and what is reasoning, and what is the role of rule of law and reasoning. The rule of law is basically to prevent any personal subjective exercise of power, and that all power shall be only exercised within the limits of the grant of power, and for the purposes of grant of power. Sir, what an official is really an agent of the state, sir, an agent of the state. When you are sitting in an office, in a public office, you're acting as an agent of the state. You're acting for the state. And so the broad principles that apply to agency, that you can only act within the power given to you and for the purposes for which the power is given to you, will apply to every official. And that is at the heart of the idea of rule of law. We don't want to be ruled by individuals. We don't want to be ruled by subjective decisions, either positive or negative. Now, let me. The implementation of the rule of law takes place through the process of reasoning. And one or two questions yesterday asked me about legal reasoning. So I find, sir, for judges, I don't want to give a theoretical. We can go to the internet and find a lot of theoretical discussion on reasoning, inductive reasoning, and deductive reasoning, and all those things. But I would like to tackle the question of what is judicial reasoning. Judicial reasoning of a court, very narrow type of reasoning. Because reasoning occurs, we are always reasoning. As human beings, we are reasoning. As I said, reasoning is simply a process of structured thought. I was telling Mr. Yaralagada yesterday that if I want to pray to God to end COVID, I can do it in a very unstructured way. If I'm very informal, and many of us have very informal relationships with God, we can say, "Yaar God, yaar, kya kar rahe ho, yaar? Kuch karo, isko band karo, jaldi band karo, God." And we'll say, "Tu ye jaldi band karo." That loving relationship, informal relationship with God. But if we are structured, then we will say, "Mukam karoti vachalam pangum lankete girim yat kripa vande paramananda madhavam," blah, 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 right? We will provide a structured prayer to God. Now, there's simple reasoning, unstructured thinking, and there is structured thinking. Now, the rule of law requires that all judicial reasoning has to be structured. And the structured reasoning, similarly, sir, take Christian prayers, Muslim prayers, Buddhist prayers, Buddham Sharanam Gacchami. So those three words, sir, structured words, profound words. or the prayers that the Muslims say, the prayers that the Christians say, structured prayers, very powerful structured prayers that will regulate our thought and our mind. When we say, when the Muslims say in prayer, they're just telling each other, Allah means God, doesn't mean Muslim God. It's like Bhagwan in Arabic, God. They're saying praise be to God, the only God. There is only one God. So immediately your mind has been structured that there cannot be more than one God, that He is the only God and He is great. So structured thinking is very, very important. And the biggest challenge I find, sir, after 17 years of close interaction with the judicial system is much as a practical matter, not when you read the judgments. The judgments are made in the head, sir. Decisions are made in the head, not on paper, by us, by and large, not on paper. And they're made in an unstructured way. But I find, sir, when we understand the process of structuring and we write down that process, the structure starts to get strong. So if I have to write down what I'm saying now, it will be much more structured than what I'm speaking now. So even writing, and someone asked me, what is the difference between judgment and justice? Judgment is basically a written record, a written statement of the reasons for the decision made by the judge, which must promote justice. So why do we reduce this to writing? And why do judges say, why do we need to write a judgment? Because it forces you to structure your thoughts. And they're resisting that structuring, sir, when they're saying we don't want to write. Now, academics like me, we can only write, sir, because we don't like the unstructured thinking. So somebody asks me something, I'll say, give me a day or two, I will send you something in writing. Opposite of judges who are saying, many judges, not all judges, who are saying, sir, why do we need to write judgments? Because it is the only way that you can ensure that your thinking is actually structured. So the first point I'd like to make, sir, is that the process of rule of law and to advance justice must be based on structured thinking. Now, what is the structure of that thinking? The core structure. The core structure which is applicable to judicial thinking, sir. Sir, it consists of the following elements, sir. The first element of that core structure is it must be based on facts. The second element of that structure of judicial thinking is there must be a connection between facts. A pattern of connection between facts. And the third element is, sir, that connection must necessarily, that connection between facts, when I say facts, I mean proved facts here. That connection between facts must necessarily lead to the existence, non-existence, nature or extent of right, liability or disability. And there is no discretion, sir. You have facts. You see connections between facts. When facts are connected, they become relevant facts or facts in issue. And when from those facts and their relationship with each other, the existence, sorry, I will not get into that. From those facts or their relationship with these facts, right, liability or disability necessarily follows. Then you've got judicial reasoning. I would say these are the three fundamentals of judicial reasoning. So in any case, in every case, ultimately, sir, if you take the Evidence Act, it says there is an assertion or denial in any suit or proceeding, civil or criminal. There is an assertion or denial of the existence, non-existence, nature or extent of right, liability or disability. That's the only reason why somebody comes to a court. It is in respect of wrong human conduct. Yesterday there was a temple festival in Thrissur, very famous temple festival. A very big tree's branch broke from a very high tree and 2 or 3 people died. Unless we can prove there is some human negligence, no one can go to a court against a tree. One of the comments said, sir, why animals are fighting and killing each other, we are not bringing action against them. I said, yes, because we are only concerned with human action. If somebody releases those animals to some, and then the animal does something, or the animal belongs to somebody and you have damaged somebody's property, yes, there can be a cause of action. So, sir, every suit or every proceeding in every court of law, Supreme Court to Junior Division Court, involves the assertion or denial, must involve the assertion or denial of the existence, non-existence, nature or extent of right, liability or disability. And that question must come from relevant fact or fact in issue. Why? Because no evidence can be introduced in any court of law in India except on relevant fact and fact in issue. And so you must have facts, and the law is what creates the right, liability or disability. In order to protect and promote justice. Justice is a pure norm, a pure set of values, no practical application. The law, like 439, is a pure hypothetical fact pattern. Somebody is in jail, this court has given the power to give bail. It doesn't tell you anything normative. But what are the values to be protected? Are the values governing human conduct that should be protected? That is why they work beautifully together, sir. The idea of justice is purely normative. Purely normative. And the laws are purely hypothetical facts, which don't tell us explicitly what the norms are. But they have to work together. The hypothetical fact pattern has to be applied and wrong conduct has to be protected, as prohibited, proscribed, as Mr. Gogone said. Keeping a 21-month-old child in jail cannot be allowed in order to uphold and take forward the normative ideas which are only in justice. And he finds them in justice and implicitly in the law. The Convention on the Rights of the Child, the Juvenile Justice Act, the standard that the best interests of the child must be protected. These normative statements are embedded in the law, authorized by the idea of justice in the Constitution. So this is how they work together, sir. Now, let me just read the definition, sir, of the 3 most important components of judicial reasoning. Very important for us to remember. I always believe, sir, that if I wake up a judge in the middle of the night at 2 o'clock while he's deeply asleep and ask him what is the definition of relevant fact, he should be able to recite it without waking up. Because it is probably the most important definition for a judge. And if he bears this in mind, then there will be a lot of clarity about what this job involves. Not a panchayat job, not a juror's job, but it's a very, very highly important and highly sophisticated job. Sir, you know that a fact is defined as very beautifully as basically a thing or a mental condition. A thing which is capable of being perceived by the senses, or a mental condition. So this is a very powerful definition, sir. It says that I cannot say a ghost is a fact because it is not a thing that is perceivable by my senses. But suppose I do perceive a ghost, others cannot. Then it becomes part of my mental condition, of which I'm conscious. Then it can be brought in as saying, look, Mohan Gopal has seen a ghost, because that's his mental condition. But you cannot say that a ghost is a thing which anybody can see with their material senses. Very simple, very beautiful architecture, sir, of fact. And we know what that we know, sir, that we know a proved fact is a fact which, when after considering the materials before it, not on the basis of some comment said, when the judge knows that the person is innocent or guilty, a judge cannot have such a view, sir, because a fact is said to be proved when after the matters before it, not before the judge, before the court, because both sides have to see it. So after considering the matters before the court believes, not the judge believes. The court is an activity. So the court as an activity comes to the belief that this fact, this thing, or this mental state, mental condition exists. Believes that it exists, or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. So we have proved facts. So the first element of structural of the structure of reasoning, of judicial reasoning, is you must have proved facts. So Mr. Gogone takes the proved facts that this child is 21 years of age. The child is not a child in conflict with the law or in need of care and protection of the law. Facts. The second, sir, is a connection between the facts. The connection established by law. So the child is in jail. The connection that the child is in jail is because the mother has been accused of a crime. Is there a connection between the child and the crime? No, there isn't. You can't draw a line from the child to the crime. You can draw a line from the child to the mother, but the child is in jail. So you connect the facts together, and then you connect the child to the rights of the child. And then you say, look, the child has a right, that right has to be protected. And is there any law that says this woman cannot be released by bail? No, he has the power to release her under bail. The assumption is that, look, an under trial should not be in jail. And there is no compelling reason that is argued that the under trial should be in jail, that she's a threat to the child. So if she actually harmed this victim, then she may harm the child. So evidence should be brought, look, she cannot be released, in which case the child cannot be with her in jail either. So the prosecution can produce evidence saying this woman has to be kept in jail because she's a threat to herself, she's a threat to others, she's a threat to the child. No such evidence was faced. No facts have been put before the court on that. And therefore, when you take these facts and the connection of these facts and the principles of law, and then the third question is there a liability for this child to be in jail? The answer is no. There is no. The facts in issue, the facts and the facts in issue, is there a liability for the child to be in jail? Is there any fact in issue that leads to the conclusion that the child must be in jail? No, there isn't. Other than that the mother is in jail. And is it in the best interest of the child alone to be released and separated from the mother? No. Is there any liability for the woman to be in jail, separate from the child? Prosecution has argued that has not produced any facts saying that there's any reason for her to be in jail. And therefore, the conclusion that mother and child must get bail necessarily follows. That word necessarily follows, fact in issue, means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of right, liability or disability, asserted or denied in any suit or proceeding, necessarily follows. So you'll find, sir, in this structure of Mr. Gogone's discussions, you can see that this decision necessarily follows from structured reasoning. And there is really no other conclusion that can emerge from the structure of judicial reasoning. However, there may be judges in courts below him or courts above him who may take a different view, who may not then we may not be able to find whether that structure of that reasoning is not obvious, unlike in his order. But in my view, that would be legally wrong, and that would be a violation of the principles of rule of law. So I'm trying to use this case to show how in a bail order, the ideas of rule of law and reasoning, which are one of the four forces that keep the judicial system in the air, operating successfully, have been followed and applied. Now, I would like to demonstrate this in the George Floyd case. After doing that, I will also deal with this question of QRTE.
Yes.
I'm dealing already with Q and R, because
yes.
this is what Q and R is: quality and responsiveness. And responsiveness, there is some access to justice issue I will address. Then we will move to timeliness and efficiency very quickly.
Yes.
And then we will come to the questions and end.
Sir, yes.
Yes, sir.
So participants kindly take a break of 10 minutes and join at 11:40.